Welcome to Division 5 of the Court of Appeals. I'm Michael Berger. To my right is Judge Dave Richmond, and to my left is Judge Jim Casebolt. We have one case on our docket this morning, People versus Saita. Am I pronouncing it right? Saita. Saita. Okay, thank you. And each side has 15 minutes. You can, appellant can reserve whatever portion of the time you wish, but you need to keep track of your own time. The arguments are live streamed and archived, so don't say anything you don't want to be in perpetuity, because there's no way to get rid of it once you say it. If anyone in the gallery has any electronic devices, please turn them off. We're told, for reasons I don't understand, that silencing them doesn't do the job, so please turn them off. And we have lawyers that we see a lot. I assume you don't have any questions about our procedures. Am I right about that? Thank you. Well, then we'll proceed to hear argument in that case.
May it please the court. My name is Taylor Ivey, registration number 50122, and I represent the appellant, Mr. Saita. Mr. Saita's Fourth Amendment rights were violated. JN did not have the authority to show the police the video on Mr. Saita's phone, and the police did not have a warrant. The police were required to have a warrant to search Mr. Saita's phone because it's entitled to Fourth Amendment protection. Cell phones are entitled to perhaps more Fourth Amendment protection than even someone's home. So
Let me ask you something. I mean, wasn't the initial search, if you call it that, done by the victim? In other words, she found the phone, she found the video of the assault, and she then suggested that the officer look at it. Is that even a search at all?
yes, the initial discovery by JN was not a search. She is a private person in her private place, and she discovered the video on her own. But when she called the police and said, I have evidence that you need to come and look at, that's the point at which the police should have gotten a warrant to search that cell phone. They knew that it was not JN's phone, and JN did not have the authority to consent to their search of it. And when they came to the house and they looked at the video on his phone, that was a search. That was a government intrusion into his reasonable expectation of privacy on his cell phone. And the facts that they knew, if they even knew these facts, were that she was his wife, that she had the passcode, and that they might have had mutual business interest. That is not enough to amount to common authority. And common authority is what those facts needed to amount to in order for the police to reasonably believe that she had the authority to consent to that search. Because they were relying on an apparent authority.
Aren't those,
I'm sorry?
let's assume we agree with you that this issue's even preserved, which is a question we'll get to. Isn't common authority, consent, authority to show it to the police, those are all factual matters, are they not?
Well, yes.
As to which the trial court made no findings because of the procedures below. So it seems like the most we could do is send it back for factual findings. We can't overturn this conviction, can we?
So it's based on the police's belief of the facts, but the problem is that the police didn't reasonably believe facts that would have amounted to common authority. They made a mistake of law, and the mistake of law was believing that that those facts could amount to common authority. And mistakes of law cannot be excused by the apparent authority doctrine. The Colorado Supreme Court has said that would eviscerate the Fourth Amendment. Police are not allowed to be ignorant of the law, just like average citizens aren't allowed to be ignorant of the law.
But what facts are we supposed to assume in order to decide the issue of law? We've got to have some facts. Nobody stipulates to the facts here. There was apparently a disagreement between the defendant and the prosecution about Officer Beach's testimony and what that related to, and whether that was sufficient apparent authority. That was never resolved. How are we to make that decision that you say is an issue of law?
Because it's a legal finding that this court can make based on all the evidence before it, and there's an extensive record about it. I mean, there's Officer Beach's testimony, even though it changed, And then there's the other officer's testimony, he didn't remember anything, but then JN also testified at trial to what happened. And even if those things are inconsistent and Officer Beach's testimony changed, I think at most, this court has the 3 facts that the officers might have known. And at the least, then they don't even have that. And so there wasn't even the possibility of apparent authority. I think that there's enough before this court to make that legal finding that there was not sufficient information for the police to believe that this was common authority. And this was also.
Why not? The victim told the officer that she ran a business with the defendant, that she had the code for the phone. Well, why isn't that enough for apparent authority? How much do you need?
Common authority is general use and joint access for most purposes. And so at most, what she had, if the facts that if she did in fact tell the officers those things and the officers reasonably believed them, was limited use for a specific purpose, and that is not common authority. And the cases that look at common and apparent authority, it's usually like a caretaker of someone's house. And so it's someone who has the key to someone's house and they can get in their house, but they can only get in there for certain purposes. So to feed their dog or take out the trash or do some specific thing. And so I think that is comparable to what this would be here if those facts were true.
And if in the course of going in the house, they find something unlawful, I don't know, a huge pile of contraband, and they call the police can't come and seize it or take it?
Not without a warrant. They don't have.
Any case law that says that?
Yes, and I'm looking specifically at Peterson versus People and People versus Moorhead.
Pearson?
Peterson?
Peterson.
Yes, that's 939 P. Second 824. And People versus Moorhead, that's a 2015 case from a division of this court, 2015 COA 131. In Peterson versus People, that's one of the caretaker cases. And People versus Moorhead, that was an ex-girlfriend who had lived previously in the defendant's apartment and had moved out. So she still had like possessions in the apartment, she still had the key to the apartment. That still was not enough to amount to common authority. The police, and Moorhead is a case that says also when it's ambiguous like this, when maybe they do and maybe they don't, the police can't just proceed in blind ignorance of the facts. They have to make further inquiry. And the police didn't here. That's exactly
Well,
what, I'm sorry.
addressing what Judge Richmond said, I mean, why don't you lose because you never sought to have the court decide the first motion to suppress? The court made a number of remarks, almost inviting a renewal of that argument. It was never done, and as a result, that motion was never ruled on. And why doesn't that fall at the, why doesn't that prevent us from even addressing the argument you're making on the merits?
You know, this proceeded in kind of a torturous fashion at trial where they filed the first unopposed, or the first motion to suppress the warrantless search and seizure. At that first hearing, they found the warrant at the end of the hearing after Officer Beach's testimony. And then there was a response to the motion to suppress the warrantless search and seizure. And there was another hearing at which the defense asked to call JN to testify because they had realized at this point that there were discrepancies, there were inconsistencies, and that they would need the testimony of all 3 people to figure out this issue. And the court denied that request at the next hearing in September. And the court denied it in pretty strong language. The court said, it does not matter to the court what the court has to determine with respect to the Riley issue that's been raised. That's what they said about JN's testimony. And it's not going to impact the court's legal ruling with respect to the motion to suppress. But that wasn't really even the end of this issue, because when there was more late discovery the next year in April, there was another hearing after the defense filed a motion for sanctions. And they re-raised this issue and asked for suppression of the video again. And the court again stated that nothing that JN had to say would impact the court's ruling with respect to the motion to suppress. And so essentially they were prevented from litigating this, and I think that they continued to pursue it. The defense continued to pursue this issue. There's a sufficient appellate record for this court to review. The trial court was given a meaningful chance to correct the error and an opportunity to make findings of fact and conclusions of law. The problem is the court was just going to the wrong place. And I think if you read what the court said before those rulings too, the court might not have even really known what they were saying about Riley, because they were saying that nobody's challenged the information, that these officers didn't manipulate the phone themselves. But that's not the issue with Riley. It doesn't matter whether the officers, physically touch the phone to search it. They watched the video on the phone, and that's a search. And they seized it, and that's a seizure. And so the Riley issue didn't have anything to do with JN's initial discovery. It didn't have anything to do with whether these officers specifically touched the phone to look at the video. It had to do with the fact that the officers came. They knew it was not JN's phone, it was Mr. Sayada's phone. They knew that he was in jail. They knew that she didn't have complete access to the phone, and they should have asked more questions, and they should have gotten a warrant before they searched and seized this phone. And the later warrant couldn't cure this initial warrantless search and seizure that was unconstitutional, because it was based on this initial search and seizure that was unconstitutional. It couldn't be separated. And also because it was overbroad. It was a general warrant. It used the exact language that the Colorado Supreme Court said in Herrera is unconstitutional general warrant language, and that's this any and law language that entitles officers to search without limit in someone's private information. And so pursuant to the overbroad general warrant, the police did seize all the information on Mr. Sayada's phone, and then the evidence of the video was introduced, and it's not relevant whether or not it was only the video. The fact that they only used the video, the fact that they only found this one piece of evidence of a crime doesn't matter to the fact that this should have been suppressed, because the principal means of effectuating the requirement, the particularity requirement of the Fourth Amendment, is to suppress all evidence seized pursuant to an overbroad general warrant.
But there was a phrase in the warrant that specified any evidence of participation in any level of sexual assault. Wasn't that the language in the warrant?
So it was any and all data, text, correspondence, electronic mail, internet histories, images, videos, and sound or graphic files to look for any level of participation in a sexual assault and any proof of ownership. And the any proof of ownership part, they already knew whose phone this was, and that's exactly what the language was in Herrera that allowed the officers to search through the entirety of the phone looking for whatever they wanted, which is what
But
they...
defendant never contested the fact that it was his phone.
Right, which is why the officers didn't need to search for any proof of ownership, but they were allowed to, and that allowed them to go through every single piece of information in that phone.
What evidence was introduced besides the video? And why then should we suppress the video if none of the other evidence was introduced?
Because the video was part of the unconstitutional search that was allowed by the overbroad general warrant, and because the case law says that the principal means of effectuating this requirement is to suppress all evidence seized pursuant to the overbroad general warrant. So not just evidence that's outside the scope of what they would have been looking for had they drafted a constitutional warrant, it's all the evidence seized pursuant to the warrant. And if there aren't any further questions, I'd like to reserve.
I do have
Oh, I'm
one
sorry.
other question, and on a different subject. Can you explain, even if the jury, let's assume cross-examination the way you contend should have been allowed, was allowed, and the jury completely disregarded Officer Castle's testimony, finding that he was biased, that he had no credibility, how would that rationally have affected the verdict?
If Officer Castle had no credibility?
Yes.
Well, I believe it was not just Officer Castle, but also Officer Beach, whose cross-examination was restricted.
No, but my question is about
Specifically Officer
the
Castle.
only issue, or the only one that was affected by the failure to allow cross, the others were leading questions. I'm directing my question specifically to Officer Castle. If the jury had completely disbelieved him, how would that have rationally changed the verdict in this case?
Well, that would have impeached his credibility and his bias, and he was the other officer who was present there when this illegal search and seizure happened initially. And so I think that it would have impeached not only his credibility, but also JN's credibility. The credibility.
Credibility as to what?
The testimony, what happened, how this video, which was a crucial piece of evidence, came to be at trial.
Right, but it seems to me you're conflating the Fourth Amendment issue, a legal issue, with the question of whether or not the jury found that your client committed the assault, which was apparently pretty clear from the tape and the video. So I'm just having trouble understanding how your argument about the restriction of the cross-examination of Officer Castle really has any impact on this case at all.
Well, it was part of Mr. Sayada's defense, his theory of defense, to show that, I think the quote was, there was an agenda in this case and the police helped facilitate this agenda, specifically Officer Castle and Officer Beach. And so necessary to his defense was impeaching Officer Castle and showing what his motive would have been or his bias. And so that was relevant to his defense, and it was crucial for him to be able to present that evidence. And I think that, you know, without being able to present that, the jury didn't get the full defense. And so he was denied a meaningful opportunity to present his defense when he was denied the opportunity to cross-examine Officer Castle about his motive and his bias. And if there are no further questions, I'd like to reserve.
I do have one, I'm sorry. A few minutes ago, when you were describing the proceedings below,
Right.
you said there was a hearing, and then you said there was a later hearing. The later hearing you're referring to is the one of April 8th, 2016? It was several months after the first suppression hearing.
Yes, there was, yes.
All
So I think this all started with, you know, the initial hearing, and I believe it was in August. Then there was a second August hearing, then there was a September hearing.
Right.
Then in October, they kind of moved over and talked about the warrant issues for a second, and then we revisited
In
the
April.
warrantless search and seizure in April.
And in that hearing, the judge said, according to the briefs, defendant has abandoned that Riley issue and put me on notice of abandoning that issue, and that's why the court then just conducted the four corners review of the warrant. Isn't that a notice to the court that the defendant's not pursuing the motion to quash, the motion to suppress the evidence?
Well, directly after that was when the court started talking about why they weren't pursuing the Riley issue, which was because the court would not allow JN's testimony, and it wouldn't affect the ruling with respect to the motion to suppress. And,
Okay.
I'm going to give you 3 minutes for rebuttal since we took up all your rebuttal time. Mr. Lofgren, you also have an additional 3 minutes.
thank you.
Thank you.
May it please the court. My name is Jacob Lofgren, registration number 40904, and I represent the people. This court should affirm the district court's judgment of conviction because the district court properly denied the motion to suppress the search of the defendant's cell phone. Below, the defendant did not establish any grounds requiring suppression of the cell phone video in this case. And there are two separate motions at issue, which this court identified in its questioning of my opposing counsel. The first motion was abandoned or waived, and the second motion did not establish facts necessary for suppression here.
Is abandon and waived the same thing, the same legal consequence?
Same legal consequence, yes, but they are two slightly different standards, especially after their Edgar decision, I would submit to this court. As it relates to the abandonment in this case, as Judge Richmond pointed out and as my brief points out, at the April 8th hearing, the district court specifically put defense counsel on notice that it was interpreting all of the facts that had led up to that date as suggesting the defendant had abandoned that first motion. They said, I believe you are abandoning the Riley issue. I never ruled on the Riley issue for that reason. And at that point, defense counsel made no indication that that was wrong or that they were asking the court to issue a ruling on that Riley motion. At that point, the issue was clearly abandoned if it was not clearly abandoned in any of the previous interactions.
And counsel for the defendant seems to be saying that because the court wouldn't allow JN to testify, that somehow undercuts this notion of abandonment. What do you say in response to that?
I think that's a confusion of what the district court was doing below. There was a lot of discussion about whether JN should testify in any of these hearings regarding the suppression issue. But what it came down to after that very first motion hearing, which was in July, all of the motions hearings after that related to the veracity of the information within the four corners of the warrant. That is why the district court let them put on any further testimony to test that veracity. Was the information in the warrant accurate as to what actually transpired in the home when the officers went to collect the phone? What the district court said with respect to JN is, there's nothing you're going to get from her that is going to affect my ruling as to the veracity of the information in that warrant. I've heard from all of the officers. They submitted to me what JN told them in the home, and that is enough for me to determine that the information in the warrant is truthful and has veracity. Did that address your question, Judge Rickman? Okay. The other fact I would point to in terms of abandonment is the email that council submitted with their second motion that also specifically said, we're moving forward on this second motion, this four corners review, and we're no longer pursuing the Riley issue. I think that, coupled with that April 8th comment by the court, clearly suggests that the first motion was abandoned. If it wasn't abandoned, it was clearly waived, because at no point is there a factual record developed to support that first motion. More importantly, there's no request for the district court to make factual findings. Without factual findings, there is no way for this court to determine how the district court viewed the actual apparent authority issue or how the district court viewed what occurred to lead to this quote-unquote search. And that leads me to my point on the merits of the first motion. In this case, there was no search by the police. What we have and what most of the evidence that was solicited at the motions hearing suggests is that the police officers arrived at the home after Jan called and said, hey, I was on this phone, I found this video, you need to collect it. They come to the home, they come in, Jan shows them the video. They don't enter the phone themselves, they never enter a passcode, they don't press any buttons. The information we have on the limited factual record that's available is she showed them the video. That's not a search.
But they seized the phone, didn't they?
They did, but what I would submit to this court is once they've seen the video, or even once Jan tells them it exists, they have probable cause to seize that phone and protect it from any evidence being destroyed.
Did you make this argument in the brief? I didn't remember seeing
Not
this.
specifically. And the argument I made in the brief that is kind of tangential to this is that the warrant, the second warrant, does clear any
But
any
you're-
violation that
you're-
occurred.
You're saying now that it's the people's position that there wasn't a search at all.
Oh, I did make that argument.
You did?
I clearly made that argument, yeah. In that I said Jan was not a government actor. So when she looked at the video, that wasn't a search. And when she showed it to the police, that wasn't a search.
But then the seizure, you're saying, is justified by plain view.
Not necessarily by
Exigent
plain view,
circumstances.
all of those things, but more particularly just the fact that once they know there's evidence on there that needs to be held, exigent circumstances or plain view, for whatever reason, they had probable cause to seize that phone. And they didn't do any independent searches of that phone until they got a warrant. And that leads to the second motion, the question of whether the warrant was overbroad. And in this case, I don't think it was. The warrant specifically says all or any evidence related to a sexual assault or to prove ownership. The search that was completed in this case was within the scope of that warrant, and that warrant was particular to this crime. It was not a broad search for any and all evidence of any crime warrant. That's not the warrant we have at issue here. And to the extent that Herrera applies here, I would point out that Herrera isn't necessarily an overbroad warrant case. What Herrera stands for is that when officers go beyond the scope of a warrant, that the evidence must be suppressed. In that case, the warrant, when read with the supporting affidavit, said that they could look for text messages related to one particular victim, Faith something. But when they actually searched the phone, they looked for evidence of other victims. And it was going to look for the evidence of the other victims that exceeded the scope of the warrant in Herrera. That was the problem. In this case, we don't have anything like that. All of the evidence seized, all of the evidence sought was particular to this crime and within the scope of the warrant.
I don't want to bog this down with technicality, but as I understand it, when they wanted to lift the content of this tape off the phone, they used some kind of device that took everything off the phone.
Right.
And then they sorted out from that just this videotape. So they did technically take more than just the videotape off the phone, but they never used the other stuff?
Yes,
They
and that's not
discarded it? I don't know how that works exactly.
right. That's not 100% clear because there's no factual development in the record.
It's not clear
What we
to me
do
either.
know is that it was plugged into the Celebrite device, which, as far as my knowledge extends, does dump the phone. But what we don't know is what the officers looked at afterward, other than the only thing they collected out of that dump was the video. That's the only thing that they tangentially hold on to. It's the only thing they turn over to the prosecution. It's the only thing that the defense has access to. So nothing in the record suggests that even if the Celebrite device did dump everything and the police officers held that at some point, that they did any search into that information for anything beyond the scope of the warrant.
Whereas in Herrera, they did look at the other information and they acted on it.
Right, and the other unique thing to remember in Herrera is it wasn't a Celebrite dump. They had to do a hand search in that case because the phone was not compatible with Celebrite. So the officer actually, the evidence in that case was actually that the officer physically went beyond the scope of the search warrant and purposely looked for information that wasn't allowed. Just want to make sure I'm addressing everything I want to address. The last thing I wanted to point out is the harmless aspect of this. With regard to every issue in this case, but even with regard to the search warrant, any error in this case has to be harmless. The defendant was not convicted of sexual assault. What he was convicted of is second-degree assault, third-degree assault, and violation of a protection order. There was ample evidence at trial to support those offenses, even if this video is not considered at all. Medical professionals testified as to the injuries J.N. sustained. She testified to them. There were pictures of those injuries. And this wasn't just some bruises. Her nose was destroyed and she needed reconstructive surgery. So there was ample evidence to support a second-degree assault charge. And with regard to the VPO, there was evidence from J.N.'s friends who were in town that night and saw the defendant and J.N. together in violation of the protection order. That evidence alone was enough to sustain those charges.
Did the video depict the assault? We
The-
haven't looked at it. I haven't
Okay.
looked at it.
To the extent this court hasn't looked at the video, all it really is, it's about an hour long, if I remember correctly. Very little actual video, only the first few minutes at the beginning, a lot of audio. So you can hear the assault, certainly, because you can hear some punches, but it's certainly not the most damning evidence of assault in this case. That would be the pictures, that would be the testimony. If this court has no further questions, I would ask this court to affirm.
Thank you.
You have 3 minutes. The clock shows 2:48, but I gave you 3 minutes, so you have 3 minutes.
Thank you. So first on just my list of things, I wanted to address warrant exception arguments for why they might have needed to seize this phone immediately after J.N. called and said that there was evidence. And just point out that there clearly wasn't exigent circumstances because it came out later that they didn't take the phone then. They left it for another 2 hours and let J.N. take the stuff off of it. So we're not talking about exigent circumstances, and I don't think it's plain view if she had to manipulate the phone to show them the video on the phone. This was a search, and it was a seizure, and it was warrantless, and it was unconstitutional. And as for the warrant, talking about Herrera, I think that the reason that the officers in Herrera were able to go beyond the scope of what the warrant should have been was because of this language, this any and all language, which the court found contains no limits. It puts no limits on an officer's search through a person's private information. And there is so much private information in a cell phone. That's why the Supreme Court has said that they are entitled to even more protection than even someone's home. There's so much private information. And a warrant that contains no limits and it allows the police to just come in with a Cellbrite device and download all of the private information on that phone is unconstitutional. It's overbroad and it's a general warrant. I also wanted to address the timing of things for the preservation issue. The email that counsel sent about the Riley issue, that came after this September hearing in 2015, after the court, very strongly denied having J.N. testify and also told them that essentially nothing was going to change the court's mind with respect to the motion to suppress. So I think it only made sense at that point for defense counsel to move forward on a different issue because the court wasn't going to let that one go any farther. And again, that was re-raised at the April hearing, and there was that colloquy about Riley and what that meant and everything. And I think that the court did misunderstand what the Riley issue was when the court was talking again about whether or not J.N. was a state actor and whether or not the officers actually manipulated the phone. And that came directly after this discussion of whether or not defense had abandoned the Riley issue. And so I don't believe that was abandoned. It was continually raised and talked about. It was before the court, and the court had plenty of opportunities to make findings of fact and conclusions of law. And this court must indulge every reasonable presumption against waiver. And so all of those hearings, all of those times that this was before the court, in the trial court, That was an adequate opportunity. Mr. Saida did not waive his claim. He did not specifically remove the claim from the trial court's consideration. And if there are no further questions, I will ask that this court remand and grant Mr. Saida a new trial.
Thank you, counsel, for your excellent arguments. The case is submitted. We'll issue a written opinion as soon as we can, and that completes our morning docket, so the bailiff can announce a recess.